few things in response to the particular points of disagreement. But I do agree that, Keith has put very well the narrowing of the disagreement in general and also the similarities between his understanding of the project of constitutional interpretation and mine. He says there will be central disagreements about what the judicial role is in a constitutional democracy and the like. Now, I argue in a section of the paper that I didn't say anything about that the three fundamental interrogatives of constitutional interpretation are: what is the Constitution, who may authoritatively interpret it, and how ought it to be interpreted? And I argue that actually the justification for judicial review that folks like Dworkin and I use is the very same classical interpretive justification of judicial review that people like Scalia and Bork use. Courts are to interpret and enforce the Constitution, whatever it is. Our disagreements are in our understandings of what is the character of the Constitution. And this takes us to Jack's discussion, too, the distinction between a scheme of abstract principles on the one hand and concrete expected applications on the other hand, or a code of detailed rules on the other hand. But formally, our justification for judicial review is the same. The disagreements are about what is the Constitution, what is the character of our commitments. Now, you said there would be disagreements about how binding original meaning is. Now, I wasn't clear whether you meant in that setting concrete original expected applications as a conception of original meaning. Okay. But there certainly will be differences. Well, let me just leave that aside then. There certainly will remain disagreements about how binding the concrete expected applications are. Now, Keith points out that in my argument about the originalist premise, I argue that much of originalist thinking is axiomatic, question-begging, and circular. And I realize that the particular line that Keith was referring to, maybe my cleverness got the better of my sense of fairness when I said, before Keith wrote his books, we thought originalism was question-begging, axiomatic, and circular. Now that he's written his books, we know that it is. I think that is unfair, because Keith, I think better than anyone else, has made arguments to justify originalism. I think that in his paper on the new originalism, he disavows some of the conventional arguments for originalism about constraint and democratic majoritarianism, and he emphasizes arguments about fidelity to the Constitution. And this brings me back to what I was saying in my opening remarks and in my chastisement of Jack for forgetting that originalists don't have a monopoly on fidelity and constitutional interpretation. I do think that much of the argument is about competing conceptions of what fidelity to the Constitution is. Is it to follow a sovereign, to use Tom's formulation? Is it, or is it to honor and realize our aspirations as a people, the way I think some of Jack's formulations imply fidelity would lead to, and my formulations following Dworkin certainly put it in those terms. So I grant that Keith does canvass many of the arguments for originalism, and I think defends it more ably than anyone else has. But I think there remain, I still do think that in places he tends to assume that fidelity just has to be originalist. And I quote a passage from his paper on the new originalism where he seems basically to say that if we're going to be faithful to the text, we have to be originalists, and I do want to dispute that. The battle is about competing understandings of originalism. And finally, I did not mean to say in my final section where I talk about what the use of history would look like in a post-originalist world, I in no way meant to say that there was anything about Keith's originalism that would require that he criticize or disavow those uses of history. I think that those uses of history that I mention by people who don't usually present themselves as originalists are not at all incompatible with the kind of project of constitutional interpretation and construction that Keith has argued for. Okay. Okay. It is, okay. On page 17, he argues, if we are to interpret, then I believe we must be originalists. When I say that is, interpretation equals originalism. He adds, but we may not want to interpret. We may want to engage in a text-based social practice, but that is not the same thing as being committed to interpretive fidelity. Okay.
Okay. Thank you.
Okay.
So, first one on the queue is Larry Solomon. So, first thing is sort of a point about the sociology of debates about originalism. And it seems to me that there are two ways that originalism gets debated. And I want to characterize these two ways as teams and theories. So one way that we can look at debates about originalism is that you have to choose which team you're on. If you're on the originalist team, then you're a conservative, and you have, growth, and from Jim's point of view, this means that you're confused or disingenuous about the role your normative commitments are playing, or you can be on the other team, right, which for Jim is sort of focused around Dworkin. And then you got this problem of people who don't seem to be playing on the right team, right? And then Jim actually has a draft list, right, of the people who are on his team. And of course we could do that. We could talk about who are the good guys and who are the bad guys, right, and who's on which team. But it seems to me that there is another way of debating these questions.
About bisexuals. I just want to know.
Or we could debate the theories. Right? And if we debate the theories, then it seems to me you have to offer an account of what originalism is, which is notably absent from this paper, right? Now, there are various attempts to do this, right? So my attempt, I say that there are two theses that are characteristic of originalists, and I try to show that this is true by going through originalists and showing that they share these two theses. The fixation thesis, right, which is that the linguistic meaning is fixed at the time each provision is framed and ratified. And then the contribution thesis, which is the idea that characteristically, it's asserted by originalists in a fairly strong form, which is that the linguistic meaning constrains constitutional doctrine, right? So both of these theses are argued for. They're not just asserted as tautological, right? That both of these claims are argued for. I think that there's more argument about the contribution thesis, right, which is argued for on a variety of grounds. Keith argues for it one way, Randy argues for it another way, Jack argues for it another way. But there are long, elaborate, developed arguments, right? But there are also arguments for the fixation thesis, right? And so if you're debating the theories, as opposed to poking at the members of the team and say, well, he's on their team, and he wasn't careful, and so that's the bad team. It seems to me that this is an entirely inappropriate way for academic discussion to be conducted, right? So You then say, right, that you make this assertion, and if anyone's being tautological here, I think this is the place where we have tautology. You make the assertion that on most important questions, right, original meaning will not be determinative, that all significant constitutional provisions are such that they leave things open, right? Now, that's just not true. There are lots of extraordinarily significant constitutional provisions that don't leave things open. And our dear friend, who seems to be at every conference but not this one, Sandy Levinson, right, has done a really good job of pointing out how extraordinarily significant provisions of the Constitution, like bicameralism and 2 senators per state, things that are of great practical importance, witness health care, right, are settled by the original meaning of the text. And now, you might be saying, well, I don't mean that stuff. What I mean is things like equal protection or separation of powers or the Privileges or Immunities Clause. And it's possible you're right, but you can't just assert that it's automatically true if the provision is relatively abstract, that the original meaning doesn't get you anywhere. So, we started the conference with Kurt and Randy talking about the Privileges or Immunities Clause, right? Neither of their investigations are complete. Both of them have hunches or hypotheses about where things are going. But I don't see how you can know in advance that it must be the case that once we learn sort of what it is, assuming you're a public meaning person, what the public meaning of the phrase was at the time, assuming you're intentionalist, what the intended meaning was. I don't see how you can know in advance how those investigations come out unless you have an unargued for prior assumption that it just must always be the case, that it's morality that is at stake. It seems to me that that's an empirical assertion and has to be argued for, and it has to be argued for case by case about each provision of the Constitution.
Okay. Well, thank you. In listing certain scholars whose use of history I said was post-originalist, I didn't mean to be engaged in the exercise that you suggested I might be, of choosing up teams and the like. What I meant to be doing there was breaking apart one of these equations, as I put it, on page 13. I have a list of things that originalists often assume, that a commitment to original understanding necessarily entails originalism. One of them is, one of the equations there I have is that the turn to history is necessarily a turn to originalism. What I was trying to do in listing those particular works was to offer them as examples of turn to history that was undertaken in a very different spirit from the typical spirit, at least officially, the typical spirit of originalism, as trying to determine authoritative meaning that binds our choices. So that was meant to be illustrative, to break apart this equation that I often see assumed in originalist writing, that if you're arguing about history, you're necessarily engaged in an originalist project. Now, as far as the question how I know in advance that there's not going to be a definitive determinant original public meaning is concerned, I'm not just assuming that there's not going to be. I'm just speaking from my experience in reading and thinking about constitutional cases and my experience in constitutional scholarship. When it comes to provisions of the Constitution that on the face of the text appear to be commitments to abstract principles or to abstract structures or to general powers, there are always going to be competing theories of those principles or those commitments, and the arguments for those competing theories are always going to travel through history. And I was suggesting that in the end, we're not going to be able to decide for our time, as a matter of constitutional law, which is the better course to take without making normative judgments that are not themselves purely historical judgments. So I don't think I'm simply assuming that. I think, though, that I'm offering that as a characterization, which I think is quite congenial to Jack's characterization of how constitutional argument about our commitments unfolds in our practice.
First, I want to just commend you and thank you for coming and flogging originalism before this group. It's it's good to have a critic here. Just as an aside, your response just then leads me to wonder whether you reject originalism at all, because I mean there were lines of it that suggested, well, it's just where there was a standard there, and original intended meaning just was that it was a standard, and that's all you could do. But I want to ask you, to go back to the moral reading of the Constitution. So I take it when you invoke this, you're invoking it as what we mean by the supreme law of the land, judicially enforceable, and so forth. The moral reading of the Constitution is one that produces the supreme law of the land that the Supreme Court and other courts enforce against other political actors. I take it that's what the moral reading of the Constitution is supposed to produce, as opposed to discussion about whether the aspirations of the framers were good or bad or indifferent or farsighted and so forth. We can have that discussion, but there's nothing that's going to create supreme law of the land out of that. That's a kind of discussion we can have, irrespective of the use of the Constitution as supreme law. So I take it that's what the quarry is of the moral reading of the Constitution. And then I want to just interrogate the prepositional phrase of the Constitution. There's a noun there, the Constitution. And I just want to know your conception of what that noun is. I mean, there's a document, there's a piece of parchment with marks on it in the National Archives. It might mean, those marks might mean something in Swahili. It might mean that a dowry must consist of at least 2 cows and so forth. But I take it that's not what you mean. There's some human beings who authored it. We know who they were. We know that they were speaking to us in English, and so they had some meanings that they were conveying. And so is there a there? Are there some meanings there? Does the 2 senators rule, for example? Is that just aspiration, or is there something concrete there that's revealed by is an empirical inquiry into what was it that those people meant by those marks on that piece of parchment? Or is it all just do the right thing, or be true to our best aspirations?
Okay, well, a couple of things on that. One, I think I implicitly draw this distinction in this paper, but in my book, Securing Constitutional Democracy, that came out a couple years ago, I developed this distinction more fully. I distinguish between answers to the question, what is the Constitution, on the one hand, and answers to the question, who may authoritatively interpret it, on the other. So I think that theories of what the Constitution is don't themselves necessarily decide the question of who is authorized to enforce what the Constitution is. So I'm not assuming that just because something's in the Constitution, it's judicially enforceable.
You said it's a supreme law.
Yes.
It binds everybody else.
Yes. But I have, in a lot of writing, written about taking the Constitution seriously outside the courts. I've explored Larry Sager's argument about judicially under-enforced norms. I've engaged considerably with Cass Sunstein's argument about judicially under-enforced norms. And there may be some moral aspirations, like aspirations to pursue the general welfare, including welfare rights, that are not judicially enforceable in the first instance. So I do distinguish between what the Constitution is and what is judicially enforceable. Okay. Second, I don't think there's anything about talking about a moral reading of the Constitution that requires us to obliterate the distinction between concrete rules and commitments to principles. Like Jack, I think that the Constitution speaks at different levels of generality. There are some very concrete rules, but there are other very abstract principles. And so when we talk about a moral reading of the Constitution, typically we're talking in particular about how to approach interpreting the more abstract commitments. And I guess we may have a different understanding of what framers are doing when they set up a Constitution. And I think Jack gets at this in some of his examples. I think that when framers and ratifiers frame and ratify words like Congress shall make no law abridging freedom of speech, or no state shall or nor shall any state deny any person the equal protection of the laws, they are not implicitly adding in parentheses after that, and what we mean by freedom of speech is what I concretely mean by freedom of speech. I think that framers commit us to more abstract commitments, fidelity to which requires disputation about and elaboration of those commitments over time.
Okay, Mike Graham.
Well, this has been pursued a little bit, but maybe I'll just ask it a little more because it strikes at things that I'm interested in particular. But I'm not sure I understand why it's helpful for your project to assert so dramatically that there isn't any ascertainable original public meaning on so many things. Because in the first place...
Well, what I said is that there will be ascertainable in the historical materials competing accounts of what the meaning of those commitments is.
What you said was that there wasn't any definitive original public meaning that was relevant to modern debates about what a constitutional rule should be.
No, it is very relevant, but it's not dispositive.
Not dispositive. Right. Not dispositive. Well, I'm sorry, I don't mean to mischaracterize what you're saying, but it does seem to me that there's an element in your paper that saying that originalism simply isn't possible. That is, it is misconceived that we are going to be able to identify an original public meaning on a lot of things. And I guess I don't understand why that's really helpful to where you want to go, because if that's what you're resting on, then to the extent that I can identify places where there is a definitive meaning, it's going to undermine it. And I think that there are some, indeed, to foreshadow, I think that we'll have this afternoon with respect to the citizenship clause. I think that the paper we have and with some additional textual accounts is pretty definitive. But in any event, I don't really understand why that matters, because wouldn't you want to say that even if there's a definitive public meaning, that we're not bound by it? And if that's not what you're saying, then if I can find a definitive public meaning, then you, I suppose, would have to concede that we are bound for it, in which case that doesn't this really push you into being an originalist, but just an originalist who thinks that a lot of things are indeterminate, and we can just argue about the extent to which things are indeterminate?
Okay, well, maybe it's some such thought that has led Jack ultimately to conceive his own project as a project of text and principle originalism. What I want to say is, I don't ever say if there were a definitive, I don't think I say if there were a definitive original public meaning, it wouldn't be binding. What I say is that there are always going to be competing normative accounts of what our constitutional commitments are, and those competing normative accounts, if they're not off the wall, are always going to have a footing in historical materials. And so those arguments about those competing normative accounts will travel through historical sources. And I'm saying that is relevant to constitutional interpretation. That is a part of constitutional interpretation. What I'm doubting is whether we can resolve our disputes among our competing normative theories simply as an historical fact of the matter by doing more history or doing careful history. I think that the disputation will go on. The arguments through history are arguments for a foothold for one's normative commitments. But I think in the end, the history itself, at least in, I go back to what Yael Kamazar said at the outset in putting a question to Jack. In much of our practice that we argue about, the history is just not going to be definitive. There's going to be a foothold for competing normative accounts of the meanings of those principles. And so I'm suggesting that it's in the normative dimension that we have to resolve those debates. In the normative dimension, we carry on the kind of discussions that Jack, I think, contemplates that we'll have. Disputes about what's the best understanding of our commitments, of our aspirations as a people, what would make our constitutional structure and framework and rights the best it can be.
Speaking as someone who plays on several different teams, this has been a very educational discussion. One reason why I happen to have gravitated over the years toward identifying as an originalist, and I say that it's kind of very tentative and in a very broad, loose sense of originalism, because I haven't had the time yet to do my homework and kind of absorb the debate enough and haven't had time to think really deeply about it. But one reason that I think a number of other people from an increasingly wide range of the political and philosophical spectrum have tended to gravitate toward originalism as a frame of reference in a very broad sense is because I have yet to figure out what the alternative to originalism is or would be. Justice Scalia came to my school a few years ago, and he is someone who frankly rankles me and I don't tend to identify with, but I thought he kind of made a good point when he somewhat smugly said, it's hard to fight something with nothing, and originalism is something, and it's not clear what the alternative is. Generally speaking, my sense so far is that the main objections to originalism are, one, that it's hard to do. It's hard to figure out what the past tells us. There are a lot of really difficult questions that it doesn't resolve. And secondly, that it lays the dead hand of the past upon us. And looking at the point 5 on page 34 of Jim Fleming's paper, I see what seems to be kind of a culmination of a dead hand objection. It says it would dishonor the past to pretend in the name of originalism that it authoritatively decides questions for us. And of those two broad objections, the one that seems to resonate with most non-lawyers out there is the dead hand objection. I converse a lot with my circle of families and friends are mostly non-lawyers. I think they're fairly bright, thoughtful people. Oddly enough, they like to discuss all this law professor stuff. And the thing I get whenever I tell them that, I tend to think that the original understanding is maybe the best thing going to understand the Constitution. They're all shocked. They think, what are you, been brainwashed by Scalia? They don't like that. But what seems to come out is, doesn't that lock us in to what these dead white slave owners said in 1789, et cetera? And my response is often to say, well, not necessarily, because in fact, an originalist interpretation could precisely lock us into a system which guarantees our freedom, the freedom of current generations to resolve questions through the democratic majoritarian political process. And that, in fact, in some ways, living constitutionalist arguments simply substitute a new dead hand, the dead hand of a Supreme Court decision interpreting a vague text in a certain way, which then becomes very hard to dislodge. And so if there's a choice of dead hands, maybe the one that was, linked to the text originally is a better starting point. So that's one response, I think, to paragraph 5 on page 34, is that it misstates or overstates what an originalist constitution does to say it authoritatively decides questions for us. To a large extent, it creates a system which leaves us free to decide questions. And then the other part, I guess, has been restated before, that there are, to some extent, it does decide questions for us, but isn't that an obvious and good thing? So, anyways, I'm trying to kind of listen and learn from this debate, but there's a lot of really great food for thought in this case, as many others, but I still am in search of what the alternative is.
Okay. Well, thanks for raising that. On pages 9 to 10, in my discussion of the Balkanization of originalism, I actually quote one of Scalia's formulations of that very criticism, that you can't beat somebody with nobody. And I try to turn it around, and I observe, now that we have so many varieties of originalism, it seems that the only thing they agree upon is their rejection of the moral reading. But I think somehow our practice is that, originalism, as Mike said at the outset, is a big tent, and is a bigger tent than many people acknowledge. But what I want to suggest is that it is a big tent that does map over or does conceal a lot of disagreement. And so Scalia's famous put-down of the alternative, I think, presupposes a greater agreement about what originalism is than our actual balkanized practice of originalism would warrant. And I do note in the paper that there are, in addition to my section on the Balkanization, I note that there are a whole lot of other new originalists and broad originalists and the like, who do a lot of different things. And it's not just conservatives, it's liberals, it's progressives. But somehow this label, originalism, has given a false comfort to people that somehow we're all on firm ground if we're originalists. But in fact, there are a whole lot of different approaches that use that label.
True, but it is interesting that Scalia, who isn't an abrasive kind of person and alienating many liberals, nevertheless, that a lot of us feel there is something there, and we tend to think, I personally feel I have significant common ground with Scalia's vision of the Constitution, and that in itself kind of startles me and makes me think there's something there in terms of originalism, and I don't see a there elsewhere. But it's a very good point. I agree, and the multiplicity of approaches is part of what, in a sense, that could sort of just redefine the debate in a way that still doesn't resolve a lot of the basic questions.
So Keith, you raised your hand before. You're a commentator here, so feel free to jump in.
So I'm still trying to get a handle, Jim, on why exactly you want to characterize yourself as a critic of originalist rather than simply someone who's not convinced that originalism is very useful in practice. Because a lot of what you've said in response to some of these concerns seem to really suggest that you don't find originalism particularly useful for resolving very main disputes that you think are actually going to arise, and I can see that that might be true in practice, and I can see why you think that might be true. But it's less clear why you think of yourself as an active critic of originalism per se, or why you think theoretically it's just a problematic theory that we'd have to reject and dispose of because there's some sort of structural flaw in the theory particularly. And I think that Brian's just pointed to what potentially might be an objection that you have, which is this sort of dead hand kind of problem. You say at several points in the paper that one problem with originalism is, sort of laying aside the circular question-begging aspect to it, is that it's also authoritarian. But but the problem with it being authoritarian, you would think, is that would lead you to want to say, well, then we ought to be able to trump original meaning. Even if we knew what the determinate original meaning was, if we could find it, we ought to be able to trump it then under certain circumstances. And yet you want to back off that. So when you specifically asked about that, you seem to want to say that's not true. So, if we know what the authoritarian meaning of the founders is, you seem to want to say, but we're stuck with that. So despite the fact that you think it's authoritarian, you seem to be willing to live with the authoritarian.
Authoritative or authoritarian?
You say authoritarian several times in the text, and so you seem to be willing to live in that authoritarian world of the founders and their text and their meaning. So I'm puzzled then as to why exactly, which Dworkin's not, by the way. I mean, Dworkin's very specific and explicit that he's willing to trump the original meaning of, even if we knew what the original meaning was, if he doesn't like it and it runs up against other commitments, he's willing to toss it out. But you seem not to be willing to take that step.
Can you give me an example of that?
Of what?
Being willing to
throw out a determinate original meaning. I mean, so if we found, for example, that the children of illegal aliens are in fact entitled to citizenship, if we thought that was a bad outcome, but the original meaning of the 14th Amendment absolutely required it, if we were a non-originalist, we might say, well, screw it, we're going to deny them citizenship anyway. And if we were a sufficiently right-wing Dworkinian, we might say, you betcha, right? And you seem committed to saying, nope, we're stuck with that particular original meaning, even though it's authoritarian, right? As with any good originalist. So I'm puzzled as to where exactly you want to get off the boat of originalism, as opposed to simply saying, I don't see where it's actually useful in most actual.
Okay, Jim, after you answer that question, can I give my answer? Because that's a question for me, too.
Okay. Well, I think that I think you've made a similar point in your writing, that it confuses matters if we just bring in everybody into the big tent of originalism. And I think that that's one reason I resist that characterization. Also, I do think that when people say, oh, well, I'm a broad originalist, oh, well, I'm an abstract originalist, oh, well, I'm a method of text and principle originalist, it continues this kind of illusion that I think Brian was just now reflecting, that we're all engaged in the same enterprise. So I just think it confuses important distinctions to lump everything in under the label originalism, except maybe the David Strauss sort of living constitutionalists. Now, also, I'm going to pass off to Jack to respond, because I didn't get the example on citizenship. I didn't understand it.
Garrett, by the way, just coined a phrase that I love. He called this a problem of being a faint-hearted non-originalist.
Right.
And that's the point of your example. That is, here's a case where you think, or I think, the right answer is birthright citizenship. I don't believe Chuck and Smith have the right answer. And if you ask me why they don't have the right answer, I would point to the evidence in Garrett's article. Right. That evidence, however, is construction, in the terms that Larry talks about, right? But I think it's really a good argument, right? And I want anybody who debates the question to accept those arguments. Now, the question is, does that commit to always accepting arguments about original construction, original expected application in every constitutional problem I face? I don't think so. But that's part of the question that Keith is asking. In other words, why am I permitted sometimes to use this evidence as being extremely strong, even conclusive, right? While I can disregard it in other contexts. That is, I take it, part of the question you're asking. And the answer I would give is going to sound very namby-pamby. It's going to sound like a lawyer's answer, right? which is lawyers combine arguments from different modalities, different forms of evidence, and they weigh them in the practice of lawyering. And sometimes it turns out that when they make certain arguments, certain kinds of arguments from modalities just seem so compelling to them that they think of them as the argument from text is just, that's it. The argument from history is absolutely ironclad. You don't have to go any further. Even if the Supreme Court had decided the one came arcade, the other came, I say wrong, just wrong. Forget that argument from precedent. But this is a very familiar experience that people arguing using modalities have. Now, I don't know if that's your view of the subject, because that's not an argument from moral principle. That's an argument from how lawyers combine different modalities of legal argument.
Well, I do, in my book, Constitutional Interpretation of Basic Questions, with Sot Barber, we do defend a fusion of approaches, or modalities, as you put it. But we offer them not as modalities that avoid moral argument. We offer them rather as sites or approaches or modalities through which moral argument is conducted. Mike, could I say one last thing, or are we about out of time?
I think one last thing will be actually it. Yeah.
Okay. Okay, I do want to come back to something Larry Solem said at the outset. This paper, this is just an outline. And this is an outline that once I finish a book that I'm working on now, I do hope over the next 5 years to work this up into a book. And so I grant that I don't always fully and fairly set up the arguments for the positions I'm labeling. But I do think in my full articles and in my book, Constitutional Interpretation of Basic Questions, where Sot and I have 3 chapters on varieties of originalism, I do think we are careful in setting up what the arguments are for the various types of originalism, even if here that's not fully reflected in the text of this outline.
Actually, my watch is fast, so we've actually got a minute or 2 more. Jack Raycom.
You have to Jack here. So, I'm kind of an outsider in this group, and a lot of it goes over my head, but it does kind of go past me in various ways. But, I think a little bit about Jack's earlier paper, position, of your position. I just found myself asking a kind of simple empirical question, which is, what are the current or outstanding issues of constitutional jurisprudence which really are most amenable to originalist takes, and which ones are ruled out? I mean, it doesn't seem to me that everything that comes up is equally amenable to originalist perspectives. That there are any of a number of issues which are outstanding and deeply conflicted with the polity, which remain objects of concern, but where the jurisprudence does not take a pronouncedly originalist turn, even though if we're all originalists now, it might. I mean, it seems to me, maybe I'm wrong on this, because you guys know this much better than I do, but it doesn't seem to me that discussions of the commerce power really kind of go back to that, or that the debates about affirmative action really go back to asking about equal protection and affirmative action in the light of understandings of 1865, 1866. I mean, the fact that originalism was, predominant in DC versus Heller, which is, where there's so much that's special and distinctive about the, about issues of gun control, and as a matter of federal jurisprudence, maybe, is that the exception that proves the rule, or is there something distinctly revealing about it? So I don't know. It seems to be something. I mean, if I look at Jack's paper, I mean, I like the characterization. There are different kinds of constitutional statements. Some of you have thought about a little bit of my own, and you can't treat each one as having an equal linguistic value that can be parsed in the same way. But a different way to approach this is to ask, instead of just using those broad terms, actually ask in a kind of empirical laundry list, which issues, pending at the moment, fit best under which sets of headings, and among those, which are the most, which are more or less, they're going to be more or less amenable to originalist takes. It seems to me that would be a different way, beyond identifying good guys and bad guys or who's on which team, a different way to kind of think about, what are the dimensions of this issue? Where does it really matter? Where does it remain relevant? It remains irrelevant in significant areas of constitutional law for lots of reasons. That would seem to me to be a telling time to do it of itself.
Don?
Well,
I'm sorry. Did you want to?
Well, in response to that, I would repeat something I say in the paper, which is that it's noticeable that the best constitutional historians like Jack and Michael, Laura Kalman, are not originalists. And so you kind of take it for granted that it's obvious that the argument about the meaning, that the argument.
No, I'm sorry, he claimed he was original.
I mean, I'm kind of an originalist. I write about the original meaning of different clauses, and I try to come up with better and worse meanings. I mean, I did that in Hamdan, I did that in DC versus Delaware, I did it in another case.
Okay,
So
but also I don't think the people who argue, the people who present themselves as originalists, don't concede that the state of affairs is as you've stated it. They don't concede that when it comes to all of these issues, you've said originalism doesn't matter, that originalism doesn't matter. They say, no, originalism will show the way. It will.
But that seems to me to be an abstract claim, which is not borne out in which, I mean, there's all this rich theoretical writing, it's
right.
growing, someone can be surprised, but anyhow, that's the
Right.
fact.
Well, I agree with your characterization, but I don't think they do.
I'm going to go, no, the full question from Don.
30 seconds. Full question from me is 30 seconds. I want to just come back to something Larry Solomon said about the contribution thesis. And one of the reasons why originalism has generates a certain amount of skepticism is the scarcity of ideologically incongruous positions that are taken under the duress of history. And so I'm just going to ask you, how much would you bet me that Randy's investigation of privileges or immunities is not going to produce a strong states' rights account of the original understanding of that position?
What? You mean, you should say libertarian, not states' rights.
Will not produce a strong states' rights interpretation. Instead, we're going to find out that the sources point in a libertarian direction. And that's not to say that it's not going to be an honest and meticulous investigation, but it's not going to produce an ideologically incongruous outcome under the force of
Well,
history.
you can have, this is a possibility, right? That human beings are constructed such that our investigations of the meanings of legal text, right, will inevitably reflect our moral priors. And, and you can make this personal. You can say that, there are particular people who are like this. I don't agree with you, Don. I think that lots of times you can look at a text and do historical work and find out that it means something that you didn't expect. And that, and I think that the Privileges or Immunities Clause may be an example of this. Just thinking about Kurt and Randy, now I happen to know their cases really well, right, because I've talked with both of them extensively about their work in progress. And both of them, my experience is that both of them, right, they have suspicions and hypotheses, right, but that frequently it turns out that the evidence turns them away from the direction that they'd like to go. I know this is the case with Randy and the chapter he presented here today, right? He had, a hope, right, that the abolitionist and anti-slavery writing would be very helpful in determining the meaning of the three grand provisions of Section 1, and it turns out it doesn't do the work that he expected it to do. Kurt, I think Kurt has a hypothesis here about the Privileges or Immunities Clause. In discussion, he's very frank that he is not sure that when he gets to evidence of public meaning that it will bear out his hypothesis. And I think that it's the cynical view, right, that scholars are just incapable of transcending their ideologies and their political orientations. I think that it is false, and that this is not the way that scholars are constructed. Now, I do think that the following is the case, that we get attracted to problems where we see evidence that can lead us in a direction where we think that when we make choices of what to work on, where we think the evidence can lead us someplace where we would like the law to go. And I think that's true whether you're an originalist or if you have any other approach, right? That you tend to be drawn to problems that you think are significant, and that the work you do might actually produce a result that is important. I think that's true, but that's very different than the suggestion that you made.
Okay, well, I guess that's all we have time for.